Today we are discussing a family related matter. A case was filed by the father-in-law and mother-in-law as plaintiffs in a civil court against their son and daughter-in-law. They are the defendants in that case. In civil cases, the plaintiff is the party who files a complaint, while the defendant is the party against whom the complaint is filed. Another case, a domestic violence case, has been filed by the daughter-in-law against the plaintiffs and her husband. Plaintiffs are mother-in-law and father-in-law. The plaintiffs, that is father-in-law and mother-in-law, who are the absolute owners of the property and building and are in possession of it on the strength of the title deed, filed a suit for permanent prohibitory injunction against their son and daughter-in-law. That is a civil case. At the time of filing the prohibitory injunction, the second defendant daughter trespassed into the plain schedule property and breaking open the lock of the house and resided there. We already told that she has filed a domestic violence case. In that case, she obtained a residence order against father-in-law, mother-in-law and her husband. The second respondent, that is daughter-in-law, presented a residence order from the judicial first class magistrate court. So later the plaintiffs amended the suit to include a relief of mandatory injunction. Mandatory injunction for compelling the second defendant, that is daughter-in-law, to vacate the house in the plain schedule property on the ground that the second defendant, that is daughter-in-law, trespassed into the plain schedule property and breaking open the lock of the house. So mainly mandatory injunction filed for evicting the second respondent. After considering the evidences, the trial court ordered it in favor of the plaintiffs, directing the second defendant daughter-in-law to vacate the property, that is plain schedule property, within 1 month, taking her belongings with her. The defendants, including their son, were also restrained by a permanent prohibitory injunction from trespassing or causing damage to the property without the plaintiff's prior permission. Aggrieved by the trial court decision, the defendants, that is son and daughter-in-law, filed a first appeal before the higher civil court, which was dismissed. Subsequently, they filed a second appeal before this high court, and we were discussing the said judgment. In the second appeal, the second defendant, that is daughter-in-law, argued that she had lawful possession of the property due to a residence order obtained under section 17 of the Protection of Women from Domestic Violence Act. The second defendant's contention is that having obtained a residence order, she have a legal possession. Making eviction through mandatory injunction is improper. Instead, a suit for recovery of possession would be the appropriate remedy. Section 2Q under the Protection of Women from Domestic Violence Act, respondent includes adult male persons. Therefore, father-in-law also would be considered as a respondent under DV Act. Section 19(1)(f) of the Protection of Women from Domestic Violence Act states that the court can direct the respondent to secure the same level of accommodation for the aggrieved person as she was previously enjoying, or to pay rent for the same, if circumstances require it, especially if the aggrieved person is evicted. If the court deems eviction necessary, the father-in-law would also be considered a respondent under section 19(1)(f) of the DV Act. This section empowers the court to direct the respondent to secure the same level of accommodation for the aggrieved person or pay rent for the same. The second defendant made several allegations of cruelty against the plaintiffs. However, since this is a civil court and the appeal arises from a civil case, the court can only consider whether the lower court decision is probable and determine the rightful ownership of the property. So the high court's scope is limited to deciding whether the eviction granted by the trial court is maintainable and not to adjudicate on other matters. The first defendant challenged the trial court decision in appeal, relying on the residence order, that is B6 order, passed by the judicial first class magistrate court. She claimed that the order granted from the judicial magistrate court, after obtained that order, she got a legal possession. Rendering eviction through mandatory injunction is improper and recovery of possession would be the correct remedy, and she placed a decision supporting for that claim. Karunagapalli Koyar Vyavasaya Cooperative Society Limited versus Shankaran Nambudiri Ramachandran Nambudiri, to substantiate the point that when legal possession is with the defendant, a suit for a mandatory injunction could not be maintainable to evict him. Besides the B6 order, that is the residence order, the defendants failed to produce any other relevant record to prove their title or possession. Moreover, The second defendant did not claim that her husband had any title or interest in the property. The property belongs to the plaintiffs, that is father-in-law and mother-in-law. Their son's wife, that is second defendant, resides in the home with permissive possession, meaning she has no legal right to stay there but is allowed to do so out of the plaintiff's kindness. Since the daughter-in-law has only permissive possession without legal rights, a recovery suit may not be viable. Instead, seeking a mandatory injunction to evict her would be a more suitable legal remedy. The DV Act safeguards the residence right of the aggrieved person, providing protection against dispossession, but does not automatically grant her legal possession or ownership rights. Even if an aggrieved person obtains a residence order under the DV Act, the aggrieved person can still be evicted through procedure established by law. In Archana Govindi Kandalwal versus Rajesh Balakrishnan Menon and others, in this case, the respondents contended that the second defendant does not have a case that the first defendant, her husband, is having any right over the plaintiff scheduled property. In the view of the section 17(2) of the DV Act, it is clear that the aggrieved person can be evicted in accordance with the procedure established by law. It is well settled by the decision of the Honorable Supreme Court in Archana Govindi that the dispute between the husband and wife under the DV Act shall not be precluded and affect the right of the landlord to possession if otherwise is entitled. The Land Council also cited the decision of the Honorable Supreme Court in Satish Chandra Ahuja versus Sneha Ahuja to substantiate the point that a suit for mandatory injunction is perfectly maintainable against the aggrieved person under the DV Act. A civil court's grant of a mandatory injunction for eviction is maintainable as the DV Act itself allows for eviction through procedure established by law. Satish Chandra decision. The DV Act allows the court to order alternate accommodation or rent payment. In this case, the father-in-law argues that as the guardian of the wife, her husband is held responsible. The court concurs, suggesting that the wife should seek relief against her husband under the DV Act for alternate accommodation or rent, not against father-in-law. The appellate court overturned the lower court's findings that the daughter-in-law had a customary right to reside in the property based on the residence order. Instead, it held that she was only a permissive occupant without any inherent rights. After considering all aspects, the court dismissed the daughter-in-law's petition, upholding the decision of both the trial court and the first appellate court. The court granted the daughter-in-law 6 months to vacate the premises. To avail this concession, she was required to file a petition and affidavit within 2 weeks, undertaking to vacate the property by the end of the 6 months period in execution proceedings filed by the father-in-law and mother-in-law for the executing the trial court's decision. This case illustrates how a person can be evicted even after obtaining a residence order from the Judicial First Class Magistrate Court. The DV Act's provision outlined the procedure for eviction. Means after obtaining residence order under DV Act, a person can be evicted through procedure established by law. This decision highlights the role of civil courts in enforcing evictions through mandatory injunctions. I am creating videos to raise awareness about legal matters and educate the public. If you had liked to stay updated, please subscribe my YouTube channel and please like and share my contents with others. Let's work together to spread knowledge and understanding of the law.